Jules, to start with you, when you came to the center to the 80s and when you started to work with Michael, can you give us an insight or flavor how discussions with Michael, especially on the Central American cases, went on and developed? I mean, how did you discuss and also basically came to conclusions what to do and how to address U.S. interventions in Central America in the 1980s?
Let me first say that Michael had tremendous success in Guantanamo and the Haiti cases, but in our conversations, both of us always felt that some of the greatest work we did was in the 1980s trying to defend Cuba and the Central American movements. And I think it reflects a lot about CCR, even though almost all of those cases lost. And Michael started me really on my path of success without victory, which I tried to subtitle My Life as a Loser, but the publisher said it wouldn't sell very well. The reason I think we felt that those cases were so important is, number one, we were really representing movements. We were representing people in struggle, people trying to get a better life, people fighting for socialism. Second, we were combining human rights and anti-war and anti-imperialism. Michael and I think the Center's overview is that we're not simply a rights organization, even though our name is Center for Constitutional Rights. We're fundamentally an organization that wants a changed society. And to do that, you have to be not just for rights, but against imperialism, against U.S. intervention abroad. And the cases that we brought in the 1980s combined, and Mike would often said, we threw the kitchen sink at them. We brought both cases challenging war, challenging U.S. intervention abroad as illegal, as imperial, and also the torture, the assassinations, the human rights violations. And we tried to combine these in one case because it was a more radical approach to the law. And one thing about the panel before us, which is the notion of the law being a tool of the elite, that's true. But I think Michael and I think the Center have a dialectical view of the law. It's a tool of the elite, and that's its fundamental, in a way, proposition. But it also is a tool that can be used by the powerless to challenge the elite, and that's the basis of the two organizations that are here today. Because we try to operate within the contradictions of the law. And in fact, the first case, which was a Central American case, a Cuban case, that I met Michael on, was exactly that. Reagan, the first thing he did when he took, one of the first things he did when he took power was to reimpose a travel ban. Carter, on Cuba, a travel ban on Cuba, which has now been somewhat lifted by Obama, but continued for 40 years. Carter, because of the Helsinki Accords, had said, we got to allow travel to Cuba. If we asked the Soviets said, hey, well, you're telling us to allow travel. What about you folks? You don't allow travel. And sure enough, Carter and the Congress changed the law to allow travel to Cuba. And one of the first things Reagan did was to reimpose that travel ban. And Michael saw this was the first step in challenging Reagan, and we sued. And the law actually was on our side, remarkably. And we won a unanimous opinion in the Court of Appeals with the judges, then Judge Breyer, who's now the justice on the Supreme Court, saying you can't read, any reasonable reader of the law couldn't read it any other way. And it turned out that 5 justices on the Supreme Court were unreasonable readers and ruled against us. And one of the justices, Justice Powell, wrote a curious opinion in which he said, I hate Castro as much as anybody else, but I'm sworn to uphold the law. But he was in dissent. And the reason he wrote that, I later found out, was that the Chief Justice, Rehnquist, went around after the argument and said, well, I don't care really what the law says. This is Cuba. and we're going to rule against it. And therefore, what we try to do is expose the contradictions in the law, because the law, while it's used by the elite, is able to be used by poor and marginalized people often to expose those contradictions. And even when we lose, our function in those cases, and now in our cases now, is to try to build a movement to really change the way the United States and other countries run. And Michael always saw that the function of these cases was building that movement. And we're using the law because because when they intervene abroad, they use torture, whatever they're doing, they're often violating the law. They don't care. And they run roughshod over the law because that's the way the elite operates. But it's our job to highlight those contradictions, and in so, to give hope and faith to a movement and to work with movements. And the last thing about those cases, then I'll turn it over to Reed, is that, and this is what Bruce said, Michael was fearless. He would go into the war zones in Nicaragua because a key point of these cases was to expose the facts. You know, often a complaint in the United States often is a dry thing. You know, it just puts out a little of the facts and then says what the law is. Michael used those complaints and films and writings to expose what was going on. And you can use the law to do that. But to expose what's going on, he had to go into the war zone. He had to take helicopters into very dangerous places and drive over places that were booby-trapped. And to get to people's stories, to talk to the victims. And one of the things about Michael is he was incredibly emotional. These really affected him. And it drove his litigation. The passion and the facts and what was going on the ground drove the litigation, not abstract legal doctrines.
And yeah, on one
I want to actually riff off two of the things that he said.
Yeah, please.
The facts and winning and the role of the law in winning and losing. I came to know Michael in 1984. I had gone on a first visit to Nicaragua with a friend whose brother was a parish priest in a little village in the north of Nicaragua, and Mary Gundrum, and she and I, as guests of the priest, were these very important foreign Americans who had come down, and there was in that little village, there was a pastoral meeting of all of the people from the mountains, and when they saw that there were 2 Americans there, they started to tell us these stories about how the Contras had come into this place and killed people, and come into this place and burned down the farms, and come into this place. And it just blew, I mean, we had heard these stories from the center, and we had heard these stories from the priest, but to be in the middle of this, it just like totally blew me away, and I felt like I had to do something about it. And I came back from Nicaragua very upset, just wanting to punch everybody in the face who wasn't dealing with this issue. And I promised myself I wasn't going to do anything stupid for like at least a week. And then it happened that there was a demonstration that week organized by the Lawyers Guild at the Federal Building in downtown Manhattan, which they were blocking the entrance. And now there's a famous picture of that with Arthur Kenoy and Bill Kunstler and Barbara Dudley and Sarah Wunsch and Michael Kennedy and, of course, Michael Ratner and Arthur. And we all got arrested. And that's where I met Michael. And I said, Michael, I have to do something about this. What should I do? And Michael said, we need the facts. He said, go back to Nicaragua and get us the facts. And that's, Jules reminded me yesterday, I also talked to Jules, and Jules said, absolutely do that. And I spent then 5 months actually going around on the back of pickup trucks, going around taking hundreds and hundreds of affidavits that were then used in the World Court case, in which the United States was condemned by the World Court to stop aiding the Contras. And it was on the front page of the New York Times. It was part of the debate. I was attacked by President Reagan. But it changed the debate about the Contras. And then when the World Court, then just go into that. The World Court then, as you know, the International Court of Justice ruled that the United States had to stop supporting the Contras. And Jules and Michael decided, well, if that's what, you can describe it better in legal terms, but we're going to go into U.S. federal court and we're going to enforce this judgment. The U.S. is bound by this World Court judgment. We're going to enforce this judgment. But to do so, it couldn't be the center. They needed plaintiffs. They needed people with standing and locus standi. So they sent me back to Nicaragua to go around to talk to Americans who were living in harm's way, who were living in the war zones. And one of the people who we recruited as a plaintiff was a young man named Ben Linder, an American engineer who was bringing hydroelectricity to this little valley in the north of Nicaragua. He drew out a map for me. He said, here is where I live, here's where the Contras are, here's where they attacked. And we presented this to a federal court. Ben wrote an affidavit, said, if the U.S. continues to violate international law, my life is in jeopardy. And therefore, I want an injunction for the U.S. government to abide by the decision of the International Court of Justice. Needless to say, the federal court threw them out, and Ben Linder was killed. And it was, for me, and I think for many of us who had lived in Nicaragua, it was this moment that, as Holly Near said in the song, it was you, but it could have been me. And here was a man who was a wonderful American doing what we all would have done had we had the courage, what we all think we would have done in 1936 in Spain. And he was killed for that. And then Michael went on to represent for many years the family of Ben Linder in a suit against the Contras. Just to talk about winning and losing. I mean, I was so used to working with Michael and Jules that I thought you always lost cases. And for me, the biggest thing about working on the Pinochet case, the biggest thing about the day in the House of Lords when the House of Lords ruled in our favor was that I was not prepared for winning a case. I was used to being right and losing. And I think, I mean, the arc of my own work has been that you need to create the political conditions to win. We didn't win the Pinochet case because, we were right. We won the Pinochet case, and we won the Hisson Habre case, and we win a lot of from stop and frisk, whatever it is, because we have created the political conditions to force the courts either to abide by the law or to aid in the progressive development of the law. You cannot win cases just because you are right. You win cases because the judges and the powers that be are sensitive to what's going on. I mean, some people know I was with Amy Goodman 2 weeks ago precisely in North Dakota. They threw out the case. They were trying to charge Amy with anything. They were forced to throw out the case because of the movement that was behind Amy. I think you can see this again and again. We have the law, but we have to fight to create the balance of power, the correlation of forces that allow us to win these cases.
I'll just feed off of Reed here. Couple of things. One is, I do think that he's absolutely right. You have to create the political conditions, create the movement, the political force to win cases. But I think the key lesson that Michael shows us is that you have to have the courage to take the cases even when you think there's a good chance of you losing. Otherwise, we didn't know what the conditions were going to be like in Guantanamo, that eventually the whole world would become against us. But we knew we had to do it. In Central America, we weren't able to win those cases. But those cases were brought because we felt we were right on the law. Michael and I never brought cases where we thought the law, that we were just making up frivolous arguments. We thought the law was on our side, like it was on our side in the Cuba case. We knew that politically we might lose. In fact, there was a good chance we'd lose. But you had to have the courage to take the cases, knowing you might lose, because you can never win unless you fight. And I guess Michael's view was justice is beginning the fight. That's where the key resistance is, taking the decision to fight oppression and to use the courts in this case to fight oppression. And then you try to figure out what the best way of winning is. Second thing, I just want to go back to read on this facts issue because I teach law, and I'm sure all of you have been through some law school somewhere. And what we tend to teach in law is the legal theory. Cases challenging oppression are usually won on the facts, are usually won because you can show that there's been oppression and injustice occurring. And that was true in the cases that I've won on solitary confinement. It was, I think, true in Guantanamo, too, eventually. And what I think as we learn law, we don't pay enough attention to the fact that what law gives us the tool to expose oppression, and it's not simply on the level of legal theory.
And maybe you can also explore a little bit from the 80s and your experience working with movements inside the US, challenging US policies, but at the same time bringing Central American cases where you represent other movements and also victims, communities' views on US imperialism in the regions, but also trying to influence US policies. I mean, what do you take from there? I mean, and that's also the interesting part for ECCHR's work to bring, that we bring, I think, movements and views together from different countries, different world regions even. I mean, what's your experience from the 80s on that?
Yeah. By the way, I also want to say that I'm only here because Michael got me involved in the center. He was the one that really brought me into the center, and I met him. He said he introduced me to the center and pushed me to get involved. Michael was an internationalist, a deep internationalist, a passionate internationalist. And what that meant was looking at what the U.S. was doing all around the world and finding its victims, whether they be back in the United States or around the globe. In the 80s, we saw that a large part of the victims were the result of Reagan's policies in Central America and elsewhere. And therefore, we had to develop theories, whether it was Peter Weiss or Michael, to try to bring those cases, bring those international crimes and international oppression back home into the United States and bring it to the United States people, through the courts or through political means or whatever means. I just want to say one last thing on this internationalism, which is that for Michael and for me, our key task was not just challenging oppression all around the globe, although we did, he did particularly. It was challenging oppression caused by our government, caused by our society, and therefore for which we felt responsible. And I also think that's why Michael played such a role in challenging Israeli oppression of Palestinians, because again he felt he had a responsibility. And while there are a lot of oppressions around the world that are caused by very, very terrible things, I think it's more important for a person to say, where's my responsibility? Where's my obligation? And for Michael, it was challenging the people who were oppressing people in his name.
And Reed, you focused also on the U.S. allies in number of cases, also Haiti, for example, but also Pinochet and not least now Hissène Habré. So what's your experience also to look into, I mean, first what's coming out of the US and their imperialism, their foreign policies, the Kissinger style of going into Latin American states, and then also looking into complicities, into local accomplice of U.S. Actions.
You know, the class that you mentioned that Michael and I taught, the first year it was called From Filartiga, because he was Filartiga. It was called From Filartiga to Pinochet. He was Filartiga and I was Pinochet. And then the next year for the following years we call it From Filartiga to Pinochet to Kissinger. And we had, one of the things that we did is that we had every student, and that's I think why people like the class so much, every student had a project, which was to basically to find a case. And so we had students look at for instance, we had several students look at the potential liability of Henry Kissinger for East Timor, for Chile, for Indochina, for other places, which actually formed the basis of the book or several of the chapters several of our students' papers formed the basis of the book by Christopher Hitchens, The Trial of Henry Kissinger. And I mean, one of the things I think that Michael and I, and I think it's an interesting, I mean, it was a kind of well, not so much a philosophical question, but, you know, after the Pinochet case happened, you know, I described it famously as a wake-up call for dictators around the world, but really what it was that it was all of a sudden a source of hope for people around the world who saw that they could use this precedent to bring to justice people who seemed out of the reach of justice. And you know, it's hard to overstate the effervescence in the human rights movement at the time. And we would have meetings with Amnesty and FIDH, and it was like, who's next? Who's the next Pinochet? And, you know, I had, both Michael and I are products of Columbia Law School and had worked with, I had been particularly with Jack Greenberg, who was the legal director of the NAACP Legal Defense Fund, who with the NAACP had executed like a 20-year strategy to overcome segregation in American schools that led to the famous Brown versus Board of Education decision. And it was a very gradualist approach. You take the easiest case and then the next easiest case until finally, you know, the system falls. And so I was very into like, okay, we're not gonna like, you know, we're not gonna go after like, and of course there were people one of the differences that the NAACP actually controlled the docket. Nobody else was bringing these cases. Whereas in the decentralized world of universal jurisdiction, everybody, I don't know, I have friends here from Belgium and Spain, but everybody was just running into the courts and suing everybody. But in any event, Michael would have none of that. Michael would have none of this gradualist approach. No. The law is there. There are people who are being oppressed. We're going to use this law. We're going to go after George Bush. We're going to go after everybody like that. And in retrospect, I mean, he was right. You know, I mean, first of all, with the exception, notable exception of the Hissin Habre case, universal jurisdiction has not been a majorly useful tool in combating impunity, but it has been an incredibly useful tool in pointing out the hypocrisy of people just laying back in front of a U.S. policy, and I think that was Michael's, whether it was in Guantanamo, the law is there. We're going to use it. You know, we have people. You're not going to tell people from Shabra and Shatila, refugee camp in Lebanon who've been that. Wait, let's wait because it's not time yet to bring this case. We have to bring some other cases that are going to establish good law. And Michael was, very clear that if the law is there, we're going to use it for the people.
And that was really true on our Central America cases. A number of the cases, human rights groups warned us not to bring. And they said to Michael, well, you're going to create bad precedent. And Michael would say, well, what's the point of precedent if you're not going to use it? Because we had a good precedent in the Filartiga case. And he just wasn't afraid of bringing important cases. I mean, he tried to do it in the most rational, reasonable, legally dynamic way he could. But he just wasn't afraid of losing because he saw that it was a key thing to developing movements and exposing the hypocrisy. That one of the key functions of the law as he used it and as we used it was to expose the hypocrisy of the elite. That here they have, I mean, the main one in international law is Nuremberg. That here there was this great precedent with which Chief Justice Jackson said if it was used against the Germans should be used against us too if we do this. And then we've never used it. And the reason that we brought that World Court case and we put front and center the Nuremberg precedent because the United States was wanting to squirm out of it. But I think also Michael had, and these cases reflected, a passion. You can't just bring cases based on reasoned decision. You have to have reason, but you have to have a passion behind the cases. And that's what he did in his arguments and his briefs and in the movement work that he did as part of the cases.
I would just add that, I mean,
Sorry.
sorry. I mean, you know, it's interesting because today, I mean, today we're faced in the world of international justice with a grave challenge. I mean, African countries are walking out of the International Criminal Court. And obviously most of them are not doing it because they have some high-minded ideal about even justice. They just want to protect their dictators. But the rationale they're using is, well, wait, this law is only being used against us. And obviously, I mean, the human rights answer is, well, yes, I mean, but all those cases are justly being used against you. But the problem is that they're not being used in other places where they should be used. And so the double standards that we all are aware of and that Michael was keenly devoted to fighting against are basically now undermining the international architecture that the human rights movement has built. As people are saying, well, if these laws are only going to apply to us, then fuck these laws.